Welcome to the IPPN Summer Course 2018 Child Protection Module. This presentation consists of 4 sessions on the topic of Children First Essential School Compliance. Session 1, Introduction and Background.
This module will deal with the following topics: the Children First Act 2015 and the important changes it brings to schools, the legal framework within which child protection exists in Ireland, the supports and training available to schools to assist in implementing the Children First Act 2015. Finally, we will examine the concept of the mandated person and the legal concept of harm. We will look at the mandated person's role in reporting and recording child protection concerns. These are the key measures which will impact on schools. There's now a legal obligation on schools to keep pupils safe from harm. All schools will produce a child safeguarding statement by the 11th of March 2018. This child safeguarding statement will include a risk assessment which will be different for every school and will make each child safeguarding statement unique to that school. All registered teachers are now mandated persons who must report child protection concerns to TUSLA, assist TUSLA in assessing child protection risk if requested. The Act defines harm and thresholds of harm for the first time, giving clarity to these concepts. The legal framework underpinning child protection. All remaining provisions of this Act came into effect on the 11th of December 2017. One of these provisions was that all schools would have to produce a child safeguarding statement by the 11th of March 2018, that is, 3 months after the enactment of the provisions. This is where the date of the 11th of March 2018 comes from. This is also known as the Whistleblowers Charter and provides protection to persons who make reports in good faith to a designated person, a TUSLA agent or a member of An Garda Síochána. It provides protection for teachers making reports to TUSLA. While schools do not come under the terms of the Freedom of Information Act, it's important to remember that TUSLA does, and that whatever information is contained in a report to TUSLA is liable to be accessed through a Freedom of Information request. Similar to the Whistleblowers Charter, it provides protection for persons making allegations regarding child abuse in good faith. These provide avenues for TUSLA to sanction registered teachers who fail in their duties as mandated persons. Where TUSLA have evidence that a teacher did not report a case of child abuse, TUSLA can report the matter to the National Vetting Bureau and to the Teaching Council, who may sanction the teacher through vetting or re-registration. This places an onus on boards of managements and DLPs to ensure that sensitive data in relation to child abuse is securely stored, either physically or electronically. These are the 2 publications which guide and govern schools' implementation of the Children First Act. The DES has published Child Protection Procedures for Primary and Post-Primary Schools 2017, which lays down the specific procedures to be followed by schools to implement the Children First National Guidelines for the Protection and Welfare of Children, published by the Department of Children and Youth Affairs. Both of these documents are summarised for principals in the IPPN Resource Bundle on Child Protection. These are the child protection supports that are available to schools. Mandated persons are all teachers registered with the Teaching Council. Mandated persons have 2 legal obligations: to report any reasonable concerns of harm above a threshold to TUSLA, and to assist TUSLA if, when requested. It should be noted that all registered teachers includes all substitute teachers who may only be in the school for a day or a few days. It's important that these teachers are made aware of the school's procedures in relation to any child protection concern they may encounter during their work in the school. SNAs and ancillary staff are not mandated persons. It's important that these persons are aware that they should report any child protection concern they may encounter to the DLP or to the Deputy DLP. Section 2 of the Act defines harm as assault, ill treatment or neglect of the child in a manner that seriously affects or is likely to seriously affect the child's health, development or welfare, or sexual abuse of a child, whether caused by a single act, omission or circumstance, or a series or combination of acts, omissions or circumstances, or otherwise. There are 4 types of abuse: physical, emotional, neglect and sexual. The first 3 have thresholds of harm associated with them, which help define the term seriously affects or is likely to seriously affect. These are set out in section 3.2 of the IPPN Resource Bundle. There is no threshold of harm for sexual abuse. All instances of sexual abuse are considered harmful. While there is no legal sanctions on mandated persons, there are consequences in terms of a teacher's career. TUSLA may contact either the Teaching Council or the National Vetting Bureau in relation to instances where a registered teacher has not been in compliance with his or her obligations as a mandated person. It's important to remember that where a mandated person becomes aware of a child protection concern and fails to report it, someone else may make the report, which might result in TUSLA becoming aware of the negligence of the mandated person. All child protection concerns in a school must be reported to the DLP in the first instance. This ensures that the school is aware of the concern and that the school, through the Board of Management and staff, can take measures to deal with the concerns. On receiving a concern, the DLP will immediately open a secure file to record all details of those concerns and the actions taken in dealing with them. Where the DLP receives a child protection concern concerning a member of the school staff, he or she will immediately report the matter to the chairperson of the Board of Management. In the case where a mandated person reports a child protection concerns to the DLP, both the DLP and the mandated person will decide whether there are reasonable grounds for concern and whether these reach the threshold for harm. Where the DLP is in doubt as to whether to report a concern or not, the DLP will seek advice from TUSLA and inform the mandated person of the advice. When seeking advice, the DLP will be explicit that he or she is seeking advice and need not give identifying details. The DLP will record the advice given by TUSLA and by whom it was given. For clarity, the DLP could send the TUSLA person who gave the advice an email summarising the advice. Where TUSLA recommends that a mandated report be made, the DLP and the mandated person will make a joint mandated report. Where the DLP disagrees with the mandated person as to the necessity for a report to TUSLA, the DLP must give the mandated person a clear written statement as to why action is not being taken. The DLP must also advise the mandated person that she or he is free to consult TUSLA and to report the concern to TUSLA. The mandated person must provide the DLP with a copy of that report. Where the concern is brought by an SNA or one of the ancillary staff, the DLP will record the concerns and consider whether there are reasonable grounds for concern, and whether these reach the threshold for harm. If in doubt, the DLP will consult with TUSLA and follow the advice given. The DLP will carefully record all advice given. Where the concern about a member of the school personnel is brought by a parent of a child in the school, the DLP will furnish the parent with a written notification within 10 school days by the DLP in relation to whether the matter has been reported to TUSLA, whether advice has been sought from TUSLA, and what that advice was. And if the DLP did not report the concerns to TUSLA, the reasons why they were not reported. The parent will also be advised that he or she may contact TUSLA directly, and that any allegation of abuse against a member of the school personnel will be dealt with under Chapter 7 of the DES Procedures for Primary and Post-Primary Schools 2017. This slide shows a Principal Aid Memoir, a PAM, from the IPPN Resource Bundle, which summarises the actions to be taken by the DLP in dealing with child protection concerns. The DLP will open a secure file when appraised of a child protection concern. It's important to ensure that all information relating to child protection concerns are anonymised when being recorded by the DLP. In preparation for this, the DLP should immediately develop a code for all members of school personnel and children to ensure anonymity. The key to the code should be available only to the DLP, the Deputy DLP, and Chairperson of the Board of Management. The identity of children who may have been abused must be preserved, as must the identity of person against whom unproved allegations have been made. The Data Protection Acts require that all sensitive information be securely stored either physically or electronically, and the DLP and the Board of Management must ensure this. It would be opportune for the DLP to suggest that the Board discuss the importance of confidentiality and anonymity in relation to unproven allegations in relation to reports which may come before the Board of Management. The DLP will record details of all contacts with TUSLA, send an email of advice to the TUSLA person you spoke to, and share the file on a need-to-know basis only.